We'll just go ahead and we'll do start introductions, but come on in if you're out there. Welcome to our first official event of spring, even though it doesn't feel like it. I wish we could have had a little bit warmer weather for our guests from Virginia, from George Mason University, but it's going to be warmer here tomorrow than where he's from. So that's a good thing.
But not me, I can handle the cold weather because I live here.
Exactly. My name is Adam Hansen. I'm the president of the Federalist Society here. I want to thank you all for coming out to our event about the Lochner Era, case, and economic liberty. The Federalist Society's mission is we're a nonpartisan, conservative, libertarian organization dedicated to freedom, federalism, and judicial restraint. We seek to educate the legal community through our programs and publications about how the limited constitutional government based on the rule of law can have a positive effect on the law and public policy. Our national membership is over 40,000 members strong. That includes judges, some law professors, students, and some judges on the U.S. or the justices on the U.S. and state Supreme Court. So if you're a member of the Federalist Society, I'd say you're in pretty good company. We take no positions on any particular legal or public policy issues, but rather we like to have an open debate, discussion on those issues. We think that's a better way to learn and grow on certain things. I'd like to introduce our two speakers for today, Professor David Bernstein on the left and Caitlin McBride on the right. Professor Bernstein teaches at the George Mason School of Law, and he's been there since 1995. He's also been a visiting professor at Georgetown Law, Michigan Law, and the Brooklyn School of Law. We are fortunate to have Professor Bernstein here to discuss his extensive work on the Lochner Era, which he's written extensively. He's written 2 books about, and countless law review articles and book chapters and the like. And if any of you are evidence fans, Professor Bernstein is an expert on Daubert evidence and has co-written a book on expert evidence. If you read the Volokh Conspiracy, you may have read many of his contributions and posts on there. If you haven't, I'd suggest checking Volokh out. It's now part of the Washington Post, so it kind of has a different look and feel to it. It's still the same great content. As I said earlier, we have Caitlin McBride. Ms. McBride is an attorney at the Institute for Justice. Originally from Colorado, Ms. McBride received her undergraduate degree from the University of San Diego, her JD from the University of Chicago School of Law, and now lives in Minnesota. She's been all over the country. Like I said, she now works at the Institute for Justice in the Minnesota chapter. IJ is a nationwide libertarian public interest law firm that has chapters throughout the country in Arizona, Florida, Texas, Washington, as well here in Minnesota. The Minnesota chapter has represented groups from taxi cabs, food truck drivers, African hair braiders, and is currently representing home bakers. And I think she'll be talking about some of her work for that ongoing litigation right now. And so with that, I'd like to turn the floor over to Professor Bernstein.
Thank you. Well, the Lochner articles aren't quite countless.
Okay.
Those are, but thank you. Anyway, thank you all for coming. The Federalist Society is a great organization. I appreciate them having me here. I remember there was a whole controversy over one nominee during the Bush administration asking, well, you remember the Federalist Society? He's like, oh, the whole to do. Federalist Society, I have a lot of friends and acquaintances and whatnot. It really is a pretty big tent. And I don't know what the point of asking someone whether they belong to the Federalist Society is, because it likely means you're not liberal. But beyond that, I'm not really sure that it had, you could have all sorts of positions, all sorts of issues, and the Federalist Society welcomes you. But since it was the Bush administration, well, they're not really going to hire someone who's liberal, so I wasn't really sure what the point of making a big deal on the Federalist Society was. People have all sorts of views, from their hardest core drug warriors to your biggest legalizers, just for example, and so forth. So on to the topic at hand. So I'm talking about Lochner versus New York, which was, for those of you who haven't covered it in class yet, or have covered it but already have forgot the way I know from my law school days, things had to go through memory shoot after finals. This was a 1905 case, which the Supreme Court held a New York state law that limited bakers to 60 hours a week, violated the right to liberty of contract, which was found and still is found in the Due Process Clause of the 14th Amendment, according to the court. Lochner is one of the cases one hears most about, maybe more than anything else. We call a whole era of jurisprudence the Lochner Era, and so forth. And it's a little bit strange, because for one thing, Lochner wasn't that big a deal when it came out. And for another thing, people often use it in a way that seems kind of odd. So just for example, let's go back to 2012, about 2 years ago. The Supreme Court's about to rule on the fate of Obamacare. And this was a case brought under the Commerce Clause. And President Obama says, I expect the Supreme Court will uphold the law because, quote, we have not seen a Supreme Court overturn a law that was passed by Congress on an economic issue like health care. A law like that has not been overturned, at least since Lochner, right? So we're going back to the 30s, pre-New Deal. Now why is this odd? Well, I already said that this case was decided under the Due Process Clause, Lochner that is, and here, in Obamacare, we're talking about the Commerce Clause, two completely different clauses of the Constitution. Moreover, Lochner was a state case under the 14th Amendment, and the Obamacare case was a case under the Commerce Clause relating to Congress. So why did President Obama bring up Lochner in this context? I'm going to address that, but before I do, I'm going to go through a whole bunch of myths about Lochner and about the proponents and opponents of Lochner during the pre-New Deal period in 1900 or so to about 1937, and then we'll get back to figuring out why Lochner would come up in a context like Obamacare. So one myth you might have heard or might hear in the future in law school about Lochner is that the problem with Lochner was that the court was trying to impose laissez-faire, complete free markets on the United States. I can go into great detail as to why that's a gross exaggeration at best, but I'll just give you one. And that one is there were 13 cases that came before the Supreme Court involving maximum hours laws. One of them, Lochner, the court overturned the law. In the other 12, the Supreme Court upheld all the rest of them. So if they're trying to impose laissez-faire, they're doing a pretty poor job of it. I think that's just just seeing that almost all the laws of maximum hours, regulating hours were upheld except for Lochner, that pretty much tells you that they weren't trying to uphold laissez-faire, and Lochner was something of an anomaly. I could talk about why it was an anomaly, but if you want to ask me that, but I want to stay on target here. So let's go to myth number 2. Lochner was the product of judicial formalism. The court was just looking abstract at the notion of the right to liberty of contract and was ignoring the actual social conditions. Well, you could say a lot of things about Lochner, why it might have been wrongly decided, but that one is refuted by the actual opinion. If you read the opinion closely, Justice Peckham, writing for the majority, says, in looking through statistics regarding all trades and occupations, it may be true that the trade of baker does not appear to be as healthy as some other trades, and is also vastly more healthy than still others. He was relying on material that was in Joseph Lochner's brief. So you can say that the court should just be deferring to the legislature, the liberty of contract right shouldn't exist, but you can say the court was being purely formalist and ignoring social conditions when the court actually specifically cites the fact that it looked into the statistics regarding the health of bakers. You may also hear that Lochner and other cases protecting liberty of contract were motivated by the justices' social Darwinism. And when I was writing my book, Rehabilitating Lochner, I really tried to find out whether there was any basis for this whatsoever. And the only thing I could come up with after extensive research was basically, here's what happened. In his dissenting opinion, which is very famous in Lochner, Justice Oliver Wendell Holmes says, the 14th Amendment does not enact Mr. Herbert Spencer's social status. Herbert Spencer was a British libertarian, very polymath. He was considered a founder of sociology, he was a philosopher, he was a scientist, etc. Very famous. But he was also a very strong libertarian. He said, we should have the law of equal freedom. You have the right to do whatever you want without any limit as long as you're not interfering with everyone else's equal rights. In other words, very libertarian. And he said that in his book, Social Status. And if you read Holmes' opinion closely, what Holmes is very clearly saying is, look, we've already upheld all sorts of laws under this Due Process Clause. We've upheld Sunday closing laws. We've upheld laws banning options trading. We've upheld laws requiring mandatory vaccination. These are all unlibertarian. Therefore, the 14th Amendment is not a libertarian document. It does not enact Mr. Herbert Spencer's social status. However, by the time Lochner became a big deal, which was not until the 1960s and 70s, people had sort of forgotten Herbert Spencer. And no one knew who Herbert Spencer was anymore. All they knew is that vaguely some later critics had called him a social Darwinist, which I can go into why that's inaccurate, but whatever. He became known as a social Darwinist. Because, aha! Holmes got their number. He figured out they were all social Darwinists. But that's just not actually what Holmes was getting at all, and moreover, as many people have pointed out over the last few decades, the only real social Darwinist on the court most likely was Holmes himself. There's really no evidence that any of the other justices were motivated by social Darwinism. Relatedly, you sometimes hear that Lochner and other cases invalidating labor regulations were a reflection of the court's preference for big corporations at the expense of the little guy. And this seems to me to be based on a really simplistic idea that all workers have the same interests and all businesses have the same interests, which you may recognize as, it was actually, clearly Marxist believe this, but also the early progressives sort of believed that the people on one side and the big interest on the other. But if you delve into the facts of some of the cases, and in this case I'll specifically talk about Lochner, you see how simplistic this is, because in Lochner, the law limiting hours of bakers was passed at the behest of the labor union that represented bakers with the cooperation of the big bakeries. Now, why the big bakeries want to help them get an hours law passed? Because the big bakeries were already organized in a factory system where the workers worked in the bakery for 10 hours a day, 60 hours a week. So they didn't care. Their bakers were already unionized, were already working 60 hours a week in a factory kind of bakery. The little guy was someone like Joseph Lochner, who is the plaintiff, of course, in Lochner v. New York, who was an immigrant from Bavaria, had a small bakery with 3 or 4 employees, and he didn't have a big factory bakery. He had one oven. And if you have one oven, what you do is you put the bread in the oven, and you take a nap. And you wait for the bread to come out, and you knead the dough and all that, but basically, you have glitches in the process where the bread's in the oven, the other bread's ready to go, but the oven isn't ready yet. So you say, okay, everyone, let's go to the back room, take a nap, and when the bread's out, we'll put new bread in. That winds up taking 14 to 16 hours to make 10 hours worth of bread. And if you have a 10-hour law, you can put those people out of business. So, and the very small immigrant-owned bakeries tended to be populated by Jewish and Italian bakers. The Bakers Union was dominated by earlier immigrants from Germany, and there was that ethnic tension as well. It was also reflected in some prejudice. This is my great-grandparents on my father's side. Their relevance will become clear in a minute. The New York State Factory inspectors were advocating for this 10-hour law, 60 hours a week, and they said, look, we need this law because the Jewish and Italian bakers are all dirty. They don't know anything about sanitation. Jews and Italians are basically hopeless when it comes to sanitation. So these are my immigrant great-grandparents who are Jewish. I think they look nice and clean and tidy myself. And he was a factory worker, by the way. He was like it wasn't like he was a doctor or something. He was just an ordinary working guy. He put ribbons in hats or something like that. So I think that may have been a product of some prejudice there. Besides all these myths, there's a more general mythology that the justices who supported liberty of contract were all horrible reactionaries, and their influence was thankfully purged from the law by their progressive opponents, who not only opposed liberty of contract, but also changed the law from having a focus in the Constitution from property and contract to the modern civil rights and civil liberties revolution of the Warren Court era and so forth. But the fact is, the progressive opponents of liberty of contract really showed very little interest in civil rights and civil liberties, especially they were very hostile to judicial review. So they showed especially little interest in having the courts protect these things. It was actually the Lochner line of cases that pioneered protections for African Americans, women, and certain civil liberties, such as the right to send one's kid to a private school. This is best illustrated with my series of slides. So, for example, who criticized the Bill of Rights for turning the United States into a monarchy of law instead of a proper democracy? Was it Herbert Spencer, who just discussed, or was it the great progressive writer Herbert Croly? Croly was the founder of the New Republic magazine. He was friends with and published Felix Frankfurter, Louis Brandeis, Learned Hand, other great progressive lawyers of the day. And the answer is, this was Herbert Croly. Didn't like the Bill of Rights. No, not didn't like property rights, not didn't like liberty of contract, didn't like any rights protected by the courts. And this was the general phenomenon. People who were more supportive of limiting government in general were in favor, in general, of limiting in other areas too, and those who were in favor of big government were in favor of it in other contexts too. So who wrote The Due Process Clause protects the right to acquire useful knowledge, to marry, establish a home and bring up children, and to worship God according to the dictates of his own conscience. Was it Judge Learned Hand, the great progressive judge, who was around actually until the late 50s, early 60s? Or was it James McReynolds, who was considered the great reactionary on the Supreme Court, the most reactionary of all the justices, one of the four horsemen of reaction who often opposed the New Deal? And the answer is, this was McReynolds. This is the case of Meyer versus Nebraska, which protects the right to learn a foreign language in school, which was banned by the state of Nebraska after World War I. And it wasn't just Hand who opposed the court striking this down. It was also Felix Frankfurter. It was also Justice Oliver Wendell Holmes, who was the great hero of the progressives who dissented in Meyer versus Nebraska. And this language, by the way, is still considered good precedent today. You'll see it in various due process cases, even through today. All right. You may at some point in your career have come across the infamous line from Justice Oliver Wendell Holmes upholding mandatory sterilization of alleged mental defectives. And I say alleged because in Buck v. Bell, it's pretty clear that Carrie Buck, who lived until the late 80s, I think, and people interviewed her later, was perfectly normal intelligence, even though she was sterilized. A whole very interesting, if anyone wants to ask me about that, interesting background there. Anyway, Holmes, whatever you think of mandatory sterilization of people who really are mentally defective, Holmes's opinion is shockingly unsympathetic to the whole issue. Doesn't really, just assumes that the government process is going to work fairly. Doesn't take the rights of the people being sterilized into account. And in fact, he says 3 generations of imbeciles are enough. So it's pretty shockingly amoral language. And in fact, one thing I learned when I was reading the book is that Holmes actually wrote to a friend of his, Harold Lasky in England, and said, the one opinion that really gave me pleasure was to write Buck v. Bell. And he added that I had to tone it down though, because Taft told me I had to tone it down to get me out. This is not really like a toned down opinion, so one can only imagine what he originally had in mind. Now, who dissented from that? No one. The court itself did not prove to be any great protectors of civil liberties in this case, because it was 8-1. But who dissented? Was it Justice Louis Brandeis, the great progressive justice, who was considered to be a great civil libertarian, or is it the second of our reactionary four horsemen, Pierce Butler? We're getting the idea now. Pierce Butler was the one who dissented. Brandeis not only did not dissent, but a year later he wrote an opinion where he said, here are some examples of the Supreme Court keeping up with modern times. He gave 3 examples. One of them was Buck v. Bell. So we know some of the justices sort of joined this opinion reluctantly, but Brandeis wasn't one of them. Which justice wrote, or I should say drafted a dissent in Buchanan versus Warley, arguing that segregation laws were inherently reasonable and therefore constitutional? And the answer here is Holmes. Holmes didn't deliver the dissent, but the draft was found in his papers. We think he didn't deliver it because he couldn't get a second vote. Buchanan versus Warley is one of these underappreciated cases that doesn't fit the standard narrative, so it's almost never taught in law school, although I teach it in my kind of law case, but very important because it involved a law in Kentucky that's made blacks and whites live in separate neighborhoods. So it's sort of like true apartheid. And it was spreading throughout the United States, and Buchanan versus Warley just pulled the plug on that. Holmes was Holmes. He wasn't really a progressive per se, the progressives liked him, but what's really fascinating is if you go back and read the law review literature at the time, all the progressives at the time, even if they were sympathetic to African Americans, which most of them weren't, they all thought Buchanan versus Warley was wrongly decided and should have upheld segregation. After all, it's just property rights. We don't care, and why should we not let the government experiment with this sort of thing, just like other progressive experiments? Finally, which justice wrote that women should accept the status of a segregated class for special treatment as a dependent? Was it future Justice Felix Frankfurter, or was it Justice George Sullivan, the third of our, or maybe the fourth of our 4 horsemen of reaction? The answer here is, of course, future Justice Frankfurter. So if you go back to the 1910s and 20s, among progressives of the day, I'm not trying to, by the way, these were progressives, not to insult current progressives. These are progressives of the 1910s and 20s, and their own shtick, which doesn't necessarily correlate with what modern progressives believe. But the progressives of that day believed that men should be able to earn enough to support their family, in part because that means they're getting a good wage, but in part because women should be home raising their family. That's a women's job. And the problem is that we have these other groups, women, especially they'd say immigrant women. These immigrant men don't know any better. They want their wives to go out to work, and African Americans and other groups that are competing with native white males and reducing their wage and forcing the women to go out to work. So we should have special rules for women that either women can earn a really high or at least a high enough minimum wage, or they should be in the workplace at all. So they have minimum wage laws only for women. This was again called the family wage, and for that matter, the progressives opposed the Equal Rights Amendment because they thought that we have an Equal Rights Amendment, the courts may use that as a rationale to hold these special working laws only for women unconstitutional. On the other hand, Justice Sutherland, who was considered again one of the four horsemen of reaction, his opinion invalidating a women-only minimum wage law in a case called Atkins versus Children's Hospital has the most egalitarian language for women of any opinion you'll see, at least till the 1960s. And he also wrote the 19th Amendment. He didn't write. He drafted the Equal Rights Amendment. He helped draft it, and he also introduced the 19th Amendment into Congress when he was a senator from Utah. So this was all a big surprise to me actually when I researched all this. Because you don't get any of this history when you learn standard constitutional law or even constitutional history. There's the good guys, Brandeis, Holmes, Hand, who were against liberty of conscience, and bad guys who were for it. So the question is how all these myths come about. So that is a very interesting historiographical question. Here's my theory. What happened is, in the 1930s and 40s, we had the two greatest crises in American history, other than the Civil War. The Great Depression and World War II. People believed at the time, almost universally, that the Great Depression required strong government intervention to fix. World War II, being a war, clearly needed strong government intervention. You need a draft and so forth and so on. In fact, one reason, if you look at the great Commerce Clause cases of the early 40s, like Wicker versus Filburn, if you're familiar with that, you say, how could the court say that it's interstate commerce, regulation of interstate commerce, to tell a farmer how much corn he could grow in his own, or wheat on his own land? You think to yourself, it's 1942, the government's sending 20 million young men off potentially to die in the jungles of Asia and the forests of Europe. The idea that the farmer has some right not to, who cares, right? It's not a good time to be asserting rights against the federal government in the 1940s. The government tell you how much bubble gum you can buy, how much milk, how much butter, but you can't buy a car. So, we had a very, very intrusive government during World War II. That's fine, though. We've had periods like that before in the U.S. World War I, the Civil War, where the government took a lot of power, and then after it was over, things got more or less back to normal. But the problem was that after World War II, the people who had sort of believed in more classical, liberal, limited government kind of ideology, basically it all died off. Even before the Great Depression, where the classical liberalism was on its last legs, and then by the time people went back and looked at these constitutional doctrines that had died off during the 30s and 40s, the Commerce Clause, the non-delegation doctrine, the Contract Clause, liberty of contract, why did anyone believe this to begin with? It's also such nonsense to us. Everyone knows that you need a lot of government, big government, in order to run modern society. If you go back and read the literature of the 1950s and 60s from liberal social scientists, they basically, in so many words, say anyone who still believes in limited government is insane. When Barry Goldwater ran for president in 1964, something like 800 psychiatrists signed a letter saying, Barry Goldwater is insane. We could tell by the crazy look in his eyes when he talks about limited government. So this is the intellectual environment that you're in at that time. And people don't understand why. So instead of going back and seriously re-looking at these doctrines and saying, did we go too far with the Commerce Clause, the non-delegation doctrine, or liberty of contract? Should we have gotten rid of them entirely? Maybe we could have just limited them or something. They said, this is all, doesn't make sense, so it's all Greek to us. It all must be the product of some weird reactionary ideology we don't understand. It all must be social Darwinism. They like big companies, they didn't like the workers, and so forth and so on. And that's where this mythology started. So, from that perspective, liberty of contract, non-delegation doctrine, Commerce Clause, 10th Amendment, all the doctrines of limited government in the past, they were all just one thing. They weren't like a lot of separate doctrines with separate origins. They were all just this reactionary ideology. They were all just Lochner, is what eventually became. For reasons of happenstance, I discussed in the last chapter, could have been anything. But it so happened that Lochner became the symbol of all this. So when Barack Obama, to go back to the beginning of the talk, when Barack Obama talks about how if the Supreme Court strikes down Obamacare, if you're going back to Lochner, he doesn't mean going back to liberty of contract doctrine against the states. He knows that. He's a constitutional law professor formerly. What he means is we're going back to this reactionary ideology where we limit government through judicial decision. Now the problem was, and that was all well and good when progressives were against judicial review in general, and against civil liberties and civil rights. But all of a sudden, in the 1950s and 60s, liberals say, no, we don't want to protect economic rights anymore, but some of those other rights we were starting to protect in the 30s and 20s and whatnot, the right to send your kids to private school, the right to learn languages, not having segregation laws, Fourth Amendment, freedom of speech, freedom of religion. We want to keep those. But we can't cite those reactionary guys from the New Deal period because then that would ruin, we're trying to discredit that stuff. So instead, we have to sort of pretend that all the great civil liberties opinions of the pre-New Deal era, all the presidents we're relying on, came from the left and not from the right. So just for example, Justice Brandeis wrote a famous opinion in Olmstead versus the United States, saying you can't have wireless, what we now call, what was then called wiretapping, which is a big issue now with the NSA. You can't have that without a warrant. And that became the great Fourth Amendment opinion. And it's a very well-written opinion, mind you. But if you go back and look at the whole time that Brandeis was on the court, the 1920s to 1930s, he was not the great champion of the Fourth Amendment at the time. He usually voted with the government. And there were a lot of cases in the 20s because of prohibition. The most sympathetic justices to the Fourth Amendment at the time were Justices Sutherland, Butler, and Vandervanter. But you never, almost never, when you read about the Fourth Amendment, ever hear about any of their opinions because they were in the majority, Brandeis was in the dissent. And if you want to show that we are really the intellectual descendants of the progressives, it's pretty hard to say, oh, let's rely on these allegedly reactionary justices. So the justices, at best, were a lot more complicated than the story made out to be. I don't want to say that the ones on the right were always right or the ones on the left were always wrong. In those days, what would have been called the progressives and the conservatives. But their story is a lot more complicated than it's been made out to be. Finally, then we have this other weird phenomenon, which is when the liberals took over the court, the modern liberals, and they wanted to protect civil rights and civil liberties, the conservatives of the day objected. And one way of objecting would have been to say, go back to what we were doing in the 20s and 30s. They knew that was defunct. They knew there was no way they were going to persuade anyone of that in those days. They said, you know what? You liberals are being hypocritical. You claim to be the intellectual descendants of the progressives, but the progressives were against judicial review. And they were against Meyer versus Nebraska and Buchanan versus Warley and all these other cases. And you're being hypocritical by now becoming state-called judicial activists you once condemned. Now, I don't know that a single liberal has ever been persuaded by this argument. To my knowledge, there have been none. But this is still the argument that was adopted by Bork and Scalia and others about the Due Process Clause. And thus, as my friend Randy Barnett likes to say, until at least very recently, the debate in American constitutional law was between modern progressives, who wanted to protect civil liberties but not economic rights within the 14th Amendment, and old progressives, who are the modern conservatives, who want to go back to being Frankfurter and Holmes and Brandeis. But those guys were not conservatives in their own era, and they would have been appalled if you had called them that. So, that's where we stand. And the question is, okay, Professor Bernstein, now we understand. When conservatives use Lochner, what they mean is you're using the 14th Amendment to protect rights that are not explicitly enumerated in the Constitution. When liberals use Lochner, they mean they're trying to limit government economic regulation. It doesn't matter through what provision. So that's useful to know. So now we know, and this, now we understand. If we're liberal, we understand when the other side says Lochner, they don't mean what we mean. So why don't we just leave it that way? It's a very useful shorthand. And so I have two answers to that. One of them is that I'm a professor and I get paid the big bucks to tell the truth, regardless of whether it makes it more or less easy to debate constitutional law. And I did the research on this history, and I'm just sharing what I've learned. But the other reason is I actually don't think this is a very productive way of debating constitutional law. So if the question is, are there any limits to the Commerce Clause in the Supreme Court? It's not that helpful to me for liberals to say, oh, well, if we put limits on the Commerce Clause, that would be Lochner. I mean, look, there's a Commerce Clause. It says Congress can only regulate interstate commerce, and a host of other things Congress can regulate, so it must mean something other than Congress can regulate everything. You have to tell us what that is. It could be very, very broad, or you could argue circumstances have changed so much that it wasn't broad 200 years ago, but is really broad now. But you have to say something, and not just it's Lochner. On the other hand, when it comes to, say, Lawrence versus Texas, the case that said that you can't restrict homosexual sodomy, it's not enough for Justice Scalia to say, as he did, the 14th Amendment no more protects the right to engage in homosexual sodomy than it protects the right to work more than 60 hours a week in a bakery. In other words, you guys are being like Lochner. I mean, the 14th Amendment protects stuff. It does protect some things. Even Scalia acknowledges that it does. And if it does, you have to explain why something as intimate and important to people as the right to engage in the only kind of sexual conduct that will be fulfilling to you in whatever kind of relationship that you're going to have, including a long-term monogamous one, is something that wouldn't be protected. And again, there may be arguments about from originalism or from textualism, whatever, but it's not enough to say, well, that would be like Lochner. So I think that if we recovered the real Lochner, which was not nearly as radical or certainly not as evil as it made out to be, and just treated it like a normal case that you may think was mistaken, but there were plenty of mistaken opinions and doctrines that we've discarded, that would deprive participants in debate over American constitutional law of this easy but ultimately vacuous rhetorical shortcut, and therefore we could have a more nuanced, civil, and constructive debate about modern constitutional law. Yeah, that's reason enough to rehabilitate Lochner. Thank you.
Thank you, Professor Bernstein, and my apologies to Felix Frankfurter for my speaking here today.
Yo, you get that joke. So I want to go back to Rehabilitating Lochner and
Why the book is called that, and just how controversial this talk is. I don't think that I'm not intimately acquainted with who your faculty members are, but I doubt that there's even a single member of your faculty who agrees that Lochner was rightly decided. I think the only professor I can think of besides Professor Bernstein is Professor Richard Epstein, who's known for being like the crazy fun libertarian law professor. So this is a really radical point of view that judges should look at laws, actually assess whether those laws make sense, and then if they don't make sense, strike them down as unconstitutional. Lochner is such an anti-precedent. I liken it to, and you guys heard of, I think it's called Godwin's Law, and that's when Hitler is the topic of the conversation. You know that you've reached a conversational low. Like, there's no recovering from that. Lochner is the legal equivalent of that. Once someone invokes Lochner and says what you're arguing for is like Lochner, it's basically the same thing in a legal conversation as saying, you're being like Hitler. That Lochner is that, defending Lochner is that controversial. So what I'll talk about is how that impacts my legal practice today in 2014 as a lawyer litigating against the government and arguing that laws should be struck down as unconstitutional. With this vast Lochner Act anti-precedent in the world, how does that actually impact my life? It makes it really hard for me to win cases. Even laws that are so stupid and so irrational that clearly the only purpose they serve is to protect an industry that lobbied for that law's existence in the first place, even those types of laws, courts will uphold them as constitutional unless you do a damn good job litigating against those laws. Even when the evidence shows that the only reason those laws exist is to protect and establish industry from competition. So we saw an example of that from Lochner, where the big bakeries, they wanted to be protected. They didn't want these small immigrant entrepreneurs to cut them out, to undercut them on price and beat them out of the market. Well, that is very active and alive today. Legislation does not work as it's depicted in that "I'm Just a Bill" song video. It's a very cute song. That ain't how it works. How it works is an established industry goes to the legislature and begs to be regulated. They beg to be licensed. Please license me. Why? Because getting a license takes time and money. Time and money that new entrants to the market, entrepreneurs, people that all they want to do is they've got a good idea, they want to enter the market and really work hard and beat people on price. Licenses make it impossible for those people to do that. Bakers are one example, and I can transition to that, and a similar factual circumstance I face right now, I'm doing a bakery case. Well, not a bakery case, but a baker case. What I'm arguing is that you should have the right to sell foods that are safe, that you baked in your home, without needing to do it in a very expensive commercial kitchen. So my clients are, that's what they're home bakers, and they want to sell cookies, muffins, cakes, even jams or pickles that they've made or baked or canned in their home. They want to sell them just basically to whoever they want. So my clients have to bake at home for a couple of reasons. My main client, Jane Astromecki, has had a very serious accident, and she cannot stand for long periods without being in a great deal of pain. And the thing about her condition is that she kind of doesn't know when the pain's going to come on, and so when it does, she basically has to be in a position to lie down immediately. So she can't bake in a commercial kitchen. She really needs to bake at home. But the law says that if you want to sell baked goods, you have to be in a commercial kitchen, or she can't be. So right now in Minnesota, you can sell home-baked goods, but you can only sell up to $5,000 worth per year, and you can only sell them from a farmer's market or a community event. So Jane can't say she has a friend who's getting married. Jane can't take an order from that friend and then drive the wedding cake to the wedding. Jane can't do that. But if Jane takes that wedding, it's like, hey, Martha, your wedding's coming up, that's exciting. How about I'll bring it to the farmer's market or whatever, you pick it up there. She can do that, she can bring this wedding cake to the farmer's market. Her friend can come and pick it up there and drive it to the wedding. But Jane can't take the exact same cake, fulfill a custom order, and then drive it to the girl's wedding. That's irrational, it makes no sense. There's no plausible way that regulation advances the public health and safety. It's the same cake, it's the same ingredients made in the same kitchen. There's just no way. And so what's the rationale behind the law? It's not to protect consumers, but I have to take in order to win this case, I have to take every conceivable rational basis the government can put forth for why these limitations on home bakers exist, and I have to negate them through evidence. Arguing all the while against the government who's going to say the court has no position striking down this law, and to do so would be the equivalent of acting like the Lochner Era courts. And that's every case that we do, that this ghost of this anti-president Lochner comes up again. Another case and let me go back to the bakers. These foods, the government has admitted that these foods are safe in their food code. So what are cakes and muffins designated as in the state of Minnesota's food code? They're called not potentially hazardous foods, which means that they're not potentially hazardous. In short form, it means that you're not going to die from eating a cookie, because that doesn't happen in the world. Cookies are safe. They're not like meat, where you put them out and you eat it after 2 days on the counter, it gets you really sick. Cookies are safe foods, and so are the other types of foods our clients want to make. Jams, pickles, they all have, this is really boring, but they have a pH of 4.6 or below, which just means that microorganisms can't grow. And in order to sell them, you have to test the pH of those foods. So these laws do not have anything to do with the public health and safety. Just like the bakery regulation, Lochner really didn't. Like Professor Bernstein mentioned, it wasn't like they were forcing workers to just go out there in the ovens and work 16 hours a day. No, it takes 16 hours to bake a thing of bread just because of the way the process is. And the difference between what the Lochner court did and what courts do today is the Lochner court actually looked at the evidence and said, hey, no, it takes 16 hours to bake bread. But courts today are so deferential, they won't even look at evidence. And a lot of government lawyers argue, you don't even have the right to do discovery because it is so easy for us to win that this case doesn't even depend on facts. And so you have no right to take depositions or serve interrogatories because facts are just plainly irrelevant. Because they can win on any rational basis. So what facts could you possibly need? You weren't going to win anyway. Another great example of why we need courts to actually do their job and look at evidence is a case I won because I had a judge who was actually willing to do that. In a case here in Minnesota where I challenged the state of Minnesota's requirement that every funeral home in the state have an embalming room. So an embalming room costs $30 grand to build, and funeral homes don't use them. The way that you do this in the funeral industry is you'll have, say you have 16 like a 17 funeral homes like Washburn McGrady does. And they have to have an embalming room in every single one. How many embalming rooms do you think they use? They use one embalming room out of 17, but they have to build 17 embalming rooms that cost $30 grand a piece. And our client challenged the law because he wanted to build a second facility. He didn't want an embalming room there. He would bring all bodies to his first facility. And he would never bring a single dead body on the premises of the second facility that he would build. He would never bring a body there. So in order to show the irrationality of the law and how it has absolutely no connection to public health and safety, at trial we showed that the second space our client had selected was in it was in a parking lot next to a Chipotle, a Massage Envy, and a nail salon. So we actually wrote in our brief that in order to get a dead body into the funeral home, you'd have to wheel it past people like eating their Chipotle burritos. So it's actually contrary to the public health and safety. I mean, this guy does not, he would be allowed to have a funeral home there. And as long as he built an embalming room there, he could have it. But it would make no sense practically or for, common public decency for him to ever bring a dead body on the premises. Oh, and by the way, this facility, you couldn't actually fit a dead body through the door of the embalming room, but as long as the embalming room was there, you filled the requirement. So these laws are irrational, right? So why are judges so hesitant to strike them down? Why is it so hard to win these cases? Because of the Lochner anti-precedent, because judges don't think it's their job to evaluate facts and look at evidence when it comes to economic regulation. Now, if you're going to say that women can do something but men can, or usually it's going to be vice versa, I mean, judges will really look at the facts of that. Or if you say, if you're a certain race, you can't be in the front of the bus, I mean that's getting struck down, and judges are going to look at facts. But when it comes to economic regulation, it's like those rights don't matter. The right not to be discriminated against based on your race, that matters, but the right to earn a living, judges don't enforce it. And that's, I mean, that really is, it's why we have this government overreach that has occurred in our modern age, because the way that our system was set up with the 3 branches was done for a reason. I mean, it made sense. It wasn't just, 3's a lovely number and all. It was because the founders recognized that industries like the funeral industry, who begged for the embalming room law, and the baking industry were going to come and beg to be licensed. And the legislature would listen to them. And the only way to counter that very real effect is for courts to say, no, you can't do that, and strike the law down. If courts aren't willing to do that, legislatures, all they do is buddy up with these industries and put forth laws that restrict our liberties, and there's no one to say that's not okay. And when judges don't ever say that's not okay, we get laws like an embalming room requirement where you can fulfill it by being next to a Chipotle. We get laws that say that Jane Astronecki can sell $4,999 worth of food as long as she brings it to a farmer's market, but she can't fulfill orders from her home, and God forbid she goes to $5,001. And we get much worse laws than that really restrict liberty. That you need a cosmetology license to do African hair braiding. Do they teach a moment of African hair braiding in cosmetology school? No. Do white girls know how to do African hair braiding? No. Does anyone who didn't learn it from their mom in Africa know how to do it? No. So why should you teach it? Why should you make them take years away from their profession and spend money that they don't have because they're immigrants trying to succeed in this country to get a cosmetology license that doesn't teach them a second of any useful information to do their craft? Because courts won't strike down the law. And the cosmetology board begs them to make hair braiders jump through these hoops because it's competition for them. And so I can't emphasize enough how much we actually need courts to do their job. In a few weeks, Clark Neely, my colleague, will be here and he'll do a much better job explaining it than me, so I encourage going to that. But I really encourage you to think deeply about Lochner's status as an anti-precedent and to challenge the commonly held belief that Lochner is this horrible decision. To really just to think about the conception of legislatures as these places that you can just walk in and knock on the door and say, hey representative, nice to meet you, I'm your constituent. This law is real bad, can you get rid of it? And they'll be like, sure, thanks for coming by. I encourage you to challenge that conception of the legislature and to know that it's not the way it is, and we really need courts to do their job. So thank you, and as long as we have time, I welcome any questions.
Does anybody have any questions for either President Bernstein or Ms. McGrath?
I never saw it here. I think I like your idea, what you're talking, because it's so real in the real world. I think the basic problem from my standpoint of view is, I think because the judge sit on the bench for so long, they're out of touch, they're out of touch with the real society, how people really do business. They don't understand it, and they create all those theories that is so beautiful but practically useless. That's why how they rule their case. That's how I think.
They've just been on the bench too long.
That's how I feel. They don't do business. They don't know how real people do in the real world, how they conduct business.
I mean, there's one interesting thing that I didn't get a chance to mention, but is worth pointing out, is that even after Lochner was overruled in the 30s and then really overruled in the 50s, a lot of state courts were still applying a much higher standard of review to economic regulation, which teaches us, first of all, teaches us something interesting. There weren't a lot of complaints in the 50s and 60s, oh my God, these state courts that applying Lochner was going crazy. I mean, occasionally there'd be a law that would just way out there, and the court would say that's fails some sort of intermediate scrutiny. And there are still even a few states that do this under their state constitutions. Anthony Sanders, who works at IJ Minnesota, wrote a really interesting paper where he showed that 1973 was a key year, and after 1973, state judges more or less stopped reviewing economic regulation in many states as seriously as they had. What happened? Anyone guess what happened in 1973? The Supreme Court decided Roe v. Wade under the Due Process Clause. And it was the more conservative judges, the state judiciary in the 50s, 60s, and 70s tended to be more conservative than the Warren Court, and they didn't follow the Warren Court precedent that we should completely abandon review of economic rights. But then what happened was, when Roe v. Wade was decided in 1973, the dissenter, Justice Rehnquist, dissenting, said, you guys are being just like Lochner. And all of a sudden, Roe became really associated with Lochner. And people like Ron Bork would say, those who say Roe must say Lochner in order to persuade the left they should be against Lochner. Against Roe. What they really did was they persuaded the conservative judges, oh, we can't say anything nice about Lochner because or anything remotely like Lochner, because that would mean we're endorsing Roe v. Wade. So again, this is just another example of how the ghost of Lochner has sort of implicated judicial willingness to protect economic rights.
You're trying to convince pro-lifers that, judges should enforce rights and that there's a role for judges. In actually looking at the facts of cases, it's really hard to do. We have a clerk, IJ, we take a clerk usually from St. Thomas at least every about 3 a year, and boy, I make it a mission of mine to explain to them why Roe versus Wade does not mean that all judicial engagement with facts is the most evil thing that's ever happened.
My own views on Roe v. Wade are very complicated. I'm not going to get into it here, but I'll just say that Roe, putting aside whether abortion should be protected or not at all, Roe is a much more extreme opinion than anything that the Lochner Court ever did, because under the old way of doing things, Lochner was something akin to what we now call intermediate scrutiny. The tiers of scrutiny we use are modern. There was no such thing. But they didn't just say, oh, you have the right to liberty of contract, therefore any regulation of contract is illegal. They said, we have liberty of contract, and therefore the government has to show us a valid police power reason for the law. They have to show us they're protecting health, safety, or general welfare somehow. When it gets to Roe said not only that there's a right to terminate pregnancy, but basically that you can't regulate it at all. And that is a much further along those lines. So the two opinions are not really coordinated that way.
I was going to bring up, how do you address the concern of judicial activism versus the engagement side of things? Because when you try to make the argument that judges should look at the facts, not just we're going to play hands off, that kind of gets, it almost sounds like activism, so is there a difference, or?
We have the great expert coming on this.
Yeah, you're
Yeah,
great,
like,
exactly.
you can
Please
start.
ask a question like that. But my response is, judicial activism is just a phrase that means I don't like what the court did in that case. And because, I mean, and the, you know, proof of that is the fact that both conservatives and liberals use that term. I would love to see a research paper on, you know, the frequency with which that term is used, and I bet you it's equal between both types of, you know, progressives or conservatives. Everyone uses it except for libertarians. I mean, it's just, to me, I don't even think judicial activism is a pejorative, frankly. I think that the question is, should judges engage in the facts of the law to determine if the fact is rational and hence constitutional? And the answer to that is plainly yes. That's the only way our system of government works. So, I'd ask Clark, but I just think it's just a pejorative that parties use when they don't like the decision that's handed down.
And from my perspective, I mean, I'm not a litigator, and I wrote a book of history, so I'm not taking any particular view on exactly what court should be doing now. I just do want to emphasize one point that often gets lost, which is that one should separate what one thinks the Constitution means from what one thinks the judiciary should do. So in other words, whether you're for or against you know, how much you think that the judges should be looking at facts, or how deferential you think they should be to the legislature, is a different question from what the Constitution actually says. Because, for example, let's say you might think that Congress, you know, one problem we have a judicial supremacist society. Congress or state legislatures often even today pass things, and they say, oh, well, we don't know if it's constitutional, we'll let the courts figure that out. But really, all elected officials taking an oath to uphold the Constitution, they are responsible in the first instance in deciding whether something is constitutional. So, for example, you could be someone like J. Harvey Wilkinson, who's a Fourth Circuit Republican judge, wrote a book against judicial activism, but that doesn't answer the question. If he were, well, I wanted to ask him, I think I did ask him this once, I don't know what he said. Judge Wilkinson, if you were a member of Congress and Obamacare came up, and he was very upset with the prospect that Obamacare would be overruled, how would you vote? Not how do you think the Supreme Court should rule it, but you have an obligation to uphold the Constitution. So even if you think the judges should be very deferential, Congress has the facts before it, Congress is the elected branch. So, you know, so this is what I would say to even whether they're conservatives or liberals, okay, Robert Bork or Scalia, you think as a judge that we should stay out of this. But do you think that because you're against judicial activism, you think that our Constitution was set up to give the legislatures the primary say in constitutional review, or because you think the Constitution doesn't actually say this? So, for example, I think if you look at the Due Process Clause and the history of it, it's fairly clear that at least some forms of economic rights were supposed to be protected. Exactly, and there's a very long anti-monopoly tradition. There were all the history of blacks not being able to get obviously paid labor because they were slaves. There's the 1866 Civil Rights Act, which the 40th Amendment was meant to incorporate, which says that all persons shall have the same right to make and enforce contracts as white persons. So there's some form of economic liberty there. So then you say, okay, there is some form there, but how much do we trust the judges to review this? And you could say we think that the legislature can't be trusted, the judges are better, and therefore we should give the judges a fairly large role. You can say we don't trust the judges, even if though the Constitution may mean this, we should be more deferential. That's fine, that shouldn't change the underlying meaning of the Constitution. And what the legislatures themselves should be doing, the constitutional arguments they should be making. And I think a lot of conservatives in particular confuse these two issues. Because they don't want the judges running amok, they then use that to skew their interpretation of the Constitution says. But it's completely two different issues. You have to first figure out what the meaning of the phrase is in the Constitution, and then decide based on other criteria. Because the Constitution doesn't say how strong judicial review should be. It implies judicial review. It doesn't say whether it should be very deferential to the legislature, a little bit deferential, or not deferential at all. And that's a separate issue. First figure out what the Constitution means, then decide what you think about judicial review.
Any more questions? They can be about Holmes's mustache.
I thank everybody for coming. Just as round of applause. I'm currently a clerk at the Institute for Justice. I work with Caitlin. They do fantastic work, and as you heard, some of the cases that they bring are unique cases, in that case that you generally think about being brought. But if anybody's interested about IJ, I'd love to talk to you about that, my work that I do, or if you want to ask Caitlin any questions after the event, Be happy to talk to you about the work and things that we're providing in the county. Grab some food on the way out. We have plenty, so thanks again. We'll see you later.